Come on, you two. I mean, this is a one-year marriage. The two of you can't reach your own agreement?
I did, Your Honor.
We did. All her stuff when she was in jail was
Mr.
put in
Judges,
that
it doesn't
storage.
matter.
Gina, are you able to text him and let him know that we're waiting for him?
Ma'am, we have a no contact order.
Gina,
Yes, sir.
I did forget to ask you if you wanted your maiden name back.
Yes, please.
What is your maiden name?
Demiro. DE_MIRO.
Thank you.
Thank you. That's my previous name. That's not my maiden name. I like to go back to my late husband's
Back to
name.
your previous, okay.
Yes.
Great, thank you.
Thank you.
Okay. Right? Can you hear me?
Mr. Judges, can you hear the court?
Yes, sir. Now I can hear you, Your Honor.
Okay, good.
Court is now in session. Gina Georges versus Ronald Georges.
For the record, this matter is before the court for continued pretrial conference subsequent to the parties have mediated with Mr. Walker for the front of the court. This hearing is being conducted via Zoom. It appears that both parties are present. The plaintiff, Gina Georges. And defendant Ronald Georges. Good morning, everyone.
Good morning.
Your Honor.
The court has been informed, Mr. Walker, the two of you have reached your own agreement. Is that correct?
Yes, sir.
Your Honor.
Ms. George, you submitted a proposed default judgment, so we'll need a revised judgment. I don't know to what extent that the consent is different from your proposed default. If you want to pick up this default judgment form, you can do that. It's in the court file here. But since you're the plaintiff, you'll need to submit another form judgment. The court's going to have Mr. Walker state what he understands to be the party's agreement. So have both of you listen carefully. And Mr. Walker will place agreement on the record, and I'll confirm that with both of you. Right, Mr. Walker.
Yes, Your Honor. The only thing at issue with this divorce action, I believe, was debt. There is a personal loan that has approximately $8,000 still left owing on it that plaintiff has agreed to pay $3,000 towards. There's a MasterCard rewards credit card that has an approximate value of $15,000 that wife has agreed to pay $3,000 also on that. So for a total of $6,000, and wife has agreed to pay $50 a month to husband directly until that debt is paid in full. There is also a fifth wheel that has been repossessed. The parties are not 100% sure what that debt is yet. The repossessor is going to sell that vehicle, take the proceeds from that sale off of the debt, and then let them know what that debt is. Once the debt is established, the parties have agreed that they are going to split that debt in half, 50-50, and each party will pay their half of the debt directly to the debtor. That any other debts that are in either party's names, they would keep and be responsible for. Spousal support, there will be none. It is forever barred. And all other issues, specifically personal property, bank accounts, retirement accounts, vehicles, life insurance, all of that has already been split. And each party will keep whatever is currently in their possession or in their name. There is no real property to divide. And plaintiff would like her name of Demiro, spelled DEMIRO, restored. I believe that is the extent of the agreement, Your Honor.
Oh, can I say something?
Yes, please.
I didn't know the default of judgment could still consist.
Well, it's in the file, but the court would not enter that this morning because Mr. Georges appeared.
Okay, thank you.
Right. So we were hoping that the court prefers that parties participate. So, Mr. Walker, there are three debts then, correct? There's a debt on the open range trailer coach, and the parties will share equally any deficiency judgment or liability on that loan. Is that correct?
That is correct.
And then there are two other loans. One is a personal loan. Well, first of all, can we establish to whom is the debt owed on the trailer coach? Who's the debtor? Is it the credit union one?
I believe so.
Mr.
Yes,
George,
Your
would you
Honor.
agree that debt on the coach is credit union one?
Yes, Your Honor.
Okay, so the judgment divorce, they're going to prepare, Mr. George should say that the trailer coach debt to credit one, you should identify credit one as being the debtor. Or the creditor, I should say. Credit one, it's credit union one, I should say.
Yes, Your Honor.
You'll share equally that once you know it. And the other two loans, one's a personal loan, and to whom is that you're going to share? You're going to Miss George is going to pay $3,000 toward that. Is that correct,
Yes.
Mr. Walker? And
Yes, Your Honor.
who is that personal loan owed to?
Credit Union 1, Your Honor.
Oh, okay. So you have more than one loan to credit union one.
Yes, Your Honor.
Okay. Okay, and there's a third debt, Mr. Walker.
Yes, Your Honor. That's a MasterCard rewards credit card.
Okay. In terms of, can you once again repeat the agreement relative to the personal loan to credit union one? The plaintiff will pay $3,000 that, $50 a month?
That is $3,000 towards each debt for a total of $6,000 and will be paid at the rate of $50 a month to Mr. Georges.
Total of $50 a month or $50 on each loan?
Total of $50 a month, Your Honor.
Toward a $6,000 indebtedness,
Correct.
okay? We should probably establish, will that be due what, the first of the month? To begin May 1st, for example?
Can you do the 15th of each month?
No, the 15th is not,
Oh, well,
Okay.
which one?
probably the 1st is better.
Okay, the first, Your Honor.
Right,
Like,
so
or
Mr.
June
George, is that
1st?
agreeable, then Miss George will pay $50 a month?
Yes, and
First
for
of
the
every month,
record,
May 1st?
and for the record, when she can't pay it, for the record, I'm not going to try to come at her. I want the record to show that when she pays it, she pays it. If she can't, she can't.
Well, we need to put something in writing in the judgment, so we'll put $50 a month commencing May 1st. And how we make that payment, by check, or you can make a direct electronic transfer?
Your
Ms.
Honor,
Georges?
can you start that June 1st? Because
You don't have $50.
I don't have $50 right now.
Mr. George, is that agreeable that the first payment begins June 1st?
Yes, Your Honor.
Okay, Ms. Georges, the last issue, are you still receiving public assistance?
Repeat that, sir.
Yes. Miss Gina, you still receive public assistance?
No,
Okay, well, you, when you filed this divorce complaint, you got a fee waiver, alleging to the clerk that you're on public assistance. There's a fine fee due of $175, and that needs to be paid. So if you're not on public assistance, unless Mr. George is willing to pay that,
Okay.
$175, and I'll give you as much time as you need to pay that. If you recall, Ms. George, when you filed this, you informed the, I'm sorry, the court actually suspended and reserved the payment of filing fee to be reviewed at entry of time of judgment. So yes, you're not a public assistance, but because you had insignificant income, the court allowed you to proceed with the divorce without having to pay that filing fee. So this judgment will have to reflect, someone's got to pay the $175 filing fee, and I will give you as much time in which to pay that. It sounds like are you currently employed, Ms. Georges?
yes, sir.
Okay. Okay, you have to pay that. Do you
Is there
want to
any
share
way-
that cost?
Can we share that cost, please?
Mr. Georges?
Your Honor, I'm going to be releasing her of 5 debts totaling over $30,000. So I would not agree with that. I'm going to read. Yeah, I'm releasing her of a huge amount of debt.
All right, so, but you're gainfully employed, Ms. George, I'll give you as much time as you need to pay that. What if I gave you till, say, June 28th?
Okay.
Okay,
So you need to put in the judgments. There's an open area, paragraph 18. If you'll see, there's a white space there. Just indicate plaintiff, you're the plaintiff, shall pay $175 filing fee to Monroe County Clerk on or before June 28th.
okay, sir.
And the county clerk is in the same office where you filed your paperwork. If in fact you can't pay, you call the court and I'll give you another month. Just don't blow it off. If you blow it off, that's when bench warrants issue. We don't want bench warrants issued for your arrest, ma'am. So the court will work with you. But they will not accept partial payments. You got to make the whole payment at one time, 175. If you pay, you can pay by credit card over the phone, but they're going to charge you a 3% fee. You're best off just paying cash so you can avoid having to pay any additional credit card fee.
Okay,
So
thank
make a
you.
note there, 175 filing fee due at Monroe County Clerk on or before June 28th. And all you gotta do is call the court if you cannot pay it, and I will give you another month. Just do not ignore that. So that needs to be included in the judgment, paragraph 18. So I knew that the court was aware that this trailer coach existed, but that's gone, right? Someone, credit union one has taken possession, repossessed that camper. Is that correct?
Yes, Your Honor.
All right. So, Ms. Georges, you'll need to revise this judgment. All you got to do is, I think you want to attach to it what's called a debt addendum. You can find that online too. If you can't find it, you come down to the courthouse, Judge Bronx Courtman will provide you with these forms. There's the 2-page judgment divorce, and you want to do, actually, yeah, you actually attach a debt addendum where you reference the trailer coach, and you can spell out these different debts in there. That you'll share equally the debt on the due to credit union one for the trailer coach. You will pay Mr. Georges a total of $6,000 at the rate of $50 a month commencing June 1st, 2024. Everything else can be similar to your prior default judgment. So if you need help with those forms, come down to the courthouse. We'll give you the forms. If you can't find them online, okay?
Yes, sir.
Then you need to sign your name, the bottom page 2 of the judgment, and date it. Then you need to get it to Mr. George for his review and approval. The court will not be divorced until the court signs the written judgment. So maybe you can meet Mr. Georges for coffee, or if you want to meet down at the courthouse together, whatever is easiest for both of you.
Your Honor, do you have the form of judgment of divorce without children?
Yes.
And then I attach the revised judgment of divorce to that?
No, you attach to it the debt addendum, the personal, it's a form that you previously attached as judgment, divorce, no children, personal property, and debt addendum. So you can reference those debts in there.
Okay.
And tell me if a no contact, how do you get it to run?
All right, you got a
Your
third party there. Hold on. This is between you and Mr. George. If there's a third party, that third party needs to remain silent.
Yes, sir.
All right, Mr. Georges, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. All right, Ms. Gina, can you please state your name and you have a confidential mailing address? Is it further true that on the date you filed that complaint, you'd been a resident of County Monroe for at least 10 days, the state of Michigan at least 6 months?
Yes.
Is it true that you married Ronald, Outta, and Georges on July 22nd, 2022, and you separated in September of 2023?
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed?
Yes, sir.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage?
No, sir.
Are you currently pregnant?
No, sir.
Do you have any questions for the court?
No, sir.
You had a question about a no contact order?
Oh, yes, sir. How would we go about signing these papers once I give them to you?
I'm sorry, how do you go about signing them? You just sign it. And then you need to you can meet Mr. George's or mail it to Mr. George's, or if you both want to come down to the courthouse and you can, outside the court's window, and you can both make sure that it's accurate and acceptable, and you can both sign it down here.
But I can mail it
I don't
to,
know. I'm not aware of a no contact order. Did you get a personal protection order?
yes, sir.
Okay. And that prohibits you from having any contact whatsoever?
Yes, sir.
All right. So I don't know what to tell you. Maybe have a third party. Maybe you got a mutual friend that can deliver it to Mr. George's.
Okay.
Or and obviously you need to both make sure that it's accurate, accurately reflects everything that's been put in the agreement. You got to specifically address all this debt. Again, you're not going to be divorced till you get to submit a fully approved judgment to the court. And obviously you want to get this done as soon as possible, correct?
Yes, I'll get it done as soon as possible.
All right. How are you going to get that to Mr. George's? You going to have a third party take it to him?
Can I mail it to him?
You can. And then Mr. George's, when you receive the judgment, you need to get that either delivered to the courthouse or get it back to Miss George's if it's acceptable.
Well, I signed the debt addendum. I don't sign divorce. I don't agree with divorce. It's against my religion, but I can sign the debt addendum and someone else can sign my name. I don't agree with
Consign
divorce.
your name, Mr. George's. We need your signature to make sure that verifies that you have agreed to this, the settlement.
I don't agree with divorce. I agree with debt.
Truck, but my black and yellow tracker's in the garage. Have a blessed day. And thank the Lord if you're not gay. Gay sex is the #1 killer. And then food addiction. Right after that, God's given you a warning for the last 10 years and nobody's listening. Have a blessed day.
Miss George is entitled to a divorce under Michigan law if she wants one.
Yeah, that's fine, but I can't sign it against my religion.
Okay, so you need to deliver that judgment to the courthouse and I can make sure that you have approved it.
Okay.
So if you don't want to sign it, you need to walk it down here and say, Judge Brock, I'm Ronald George's and here's the judgment.
Okay. I can do that.
Don't put on there they refuse to sign it.
Okay.
All right, Mr. George's, please state your name and current address for the record, please.
Ronald Olteen George's, address 619 Elm Street, Carlton, Michigan 48117.
Thank you. Mr. George's, did you hear the testimony of your wife, Gina, this morning?
Yes, Your Honor.
Was her testimony true and accurate, to the best of her knowledge?
Yes, Your Honor.
Do you have any questions for the court?
I need a record that will help her here of, I need it on the record because she has her name on an American Express card with $11,000 debt. I wanted to make sure that it was on the court record that she's being relieved from that. Her name is and signature is on that credit card for American Express. Her name is also on a Home Depot card. I'm going to release her from that debt. And I'm releasing her of over $3,000 for storage while she was incarcerated at Tennessee, Warren County Jail for 14 days.
All right, hold on, Mr. George's. We either have an agreement or we don't. The agreement is that any debt in her name, she will pay.
Okay.
So if Home Depot, American Express are in her name, it's not your responsibility.
Okay. Okay. Oh, the court understands that. That's fine.
So you want to make sure that your judgment actually reflects that. Now, if the divorce says you pay the American Express, you pay Home Depot, that's why you want to review it and you want to approve that judgment, Mr. George's. You're being bullheaded and you say, oh, my religion doesn't agree with this. I'm not going to sign the judgment. Mr. George, you want to make sure that judgment accurately reflects your agreement.
Well, I just want to make sure she's covered. Her name's on these credit cards. So as long as you're telling me legally,
Mr. George's.
Okay. Yeah.
Mr. George's, is your name on those credit card debts?
Yes.
The American Express?
Yeah, mine and hers.
You have to address all joint debts.
We did. I agreed to just accept this amount of money and wipe all
Hold
of these.
on. I'm just informed of a debt to Credit Union One and a personal loan.
Yeah,
That you're
yeah.
gonna, that she's gonna reimburse you.
And in return, I'm letting all of these other debts go.
I don't know what you're talking about, other debts go. My question is, you just raised a question about American Express card. And my question is, in whose name is that credit card debt?
Both of our names.
Okay, that's gotta be addressed. Okay, what other, you gotta address in your judgment divorce, all joint debts.
We did. Home Depot credit card in her name and my name.
Okay, Mr. Walker, did they bring your attention to Home Depot and American Express card, then what joint names?
Home Depot, Your Honor, I did not know was in both names. The American Express, it was my understanding that there was a card in Mr. George's name and a card in Mrs. George's name. Mrs. George's informed me that the card in her name was never activated, so she has no debt in her name with the American Express.
So as long as the
Josh has
American
all the
Express is in
copies.
your name.
Josh has all copies of the Home Depot. It's in that paperwork on the back pages is a copy of her name on a Home Depot credit card and her name and signature on the American Express. And I agreed to just take these three and remove all of these thousands of dollars of debt. There's a storage unit also, thousands of dollars of debt that was gotten. And we've agreed to just let all that go. I'm taking $30,000 worth of debt in exchange for what we agreed with you, Your Honor.
It's got to be spelled out in the judgment.
Okay.
That's why
That's
you
what
need to
Josh
review
told
and
us.
approve this.
We just did what Josh said, Your Honor.
Well, but after you did that, you said, well, there's two other debts in the joint names. We need to address all joint debt. Spell it out.
Well, Josh, I assumed that that's what Josh was doing with these three debts, is making sure these other debts are not going to come after her.
Mr. Georges, maybe the two of you need to hire lawyers.
We can't afford it. I've had 9 surgeries, Your Honor.
Your
Okay,
Honor,
let
can
me
I?
ask you again.
In
Hold on.
judgment
Is the
of the,
American Express card in both names?
no,
Tell him it's a business.
it's a business card, Your Honor.
Right
I don't care
here.
whether it's a business card, a commercial card, personal card. Is it in both names?
Yes.
Yes, Your Honor. It's right here. Copy of all of them.
Right.
The Home Depot with her
All right,
name
all right.
on it.
As long as we don't have an agreement, so let's
Yeah.
just set this for a quick trial.
Okay.
Come on, you two. I mean, this is a 1-year marriage. The two of you can't reach your own agreement?
I did, Your Honor.
We did. We did. We did. We agreed on these three things in exchange to remove all of this $30,000 of debt, Your Honor. We did.
Mr. Georges, we have to address in judgment of divorce any joint debt. Yes, any debt in your name, you pay. Any debt in Miss George's name, she'll pay. The agreement that I've heard is that there are 3 debts. One is going to share equally the debt to Credit Union One on the trailer coach. You're going to share, and Miss George is going to pay $3,000 toward the MasterCard reward credit card. And then there's a $3,000, and she's going to pay $3,000 toward a personal loan. I'm not sure to whom that personal loan is due. That's I'll do the Credit Union One, correct, Mr. Walker? Yeah, so you have.
Yes, Your Honor, that's Credit Union One.
There was no discussion agreement about American Express and Home Depot. So you're throwing a wrench into everything, Mr. Georges. You say the Home Depot is in both names?
Yeah, everybody has a copy of this. Everybody. Josh has a copy. Gina has a copy. Everybody has a copy of everything.
Court's not in receipt of such a copy, Mr. Georges, so I can't don't flash it because I can't read it on the screen. Ms.
Josh
Georges,
has
there's Home Depot in both names?
Yeah,
No.
Josh has it.
Whatever that says, it says 2018, and we wasn't married to 2022. And that's it for his business.
Well, it doesn't matter. Was your
Home
name
Depot
added to
is
the card?
personal.
The judgment needs to address. Are you gonna pay the Home Depot card, Mr. Georges?
Yeah, I'm gonna take care of all this debt, Your Honor.
Okay, all right, so Ms. Georges, in your judgment, you have to spell out, Mr. Georges will pay the Home Depot and American Express card.
Okay. Josh didn't tell us that. We didn't know.
You didn't tell him that was a joint debt. So we gotta spell out any joint debts. So in
Okay.
addition to the two debts, the credit union one and the debt to MasterCard, you need to put in the judgment, Ms. Georges, that Mr. Georges will pay in full the outstanding balance of the American Express as well as the Home Depot card.
And
That
Dwayne
clears up
Storage.
those.
And Dwayne Storage.
Okay, we don't have an agreement because Ronald's changing the whole agreement that we just did. So I
No,
asked
he
for
did. He
default.
just was specifying, hold on, Ms. Georges. You just got to put in the judgment that he shall be responsible for the American Express and Home Depot card because it's
Yeah.
both names. Now, this storage expense is also both names.
The storage,
Georges?
we had both of our stuff. All her stuff when she was in jail was
Mr.
put in
Georges,
that
it doesn't
storage.
matter. Mr. Georges, the question, listen to the question. Is that debt in both names?
I haven't asked Dwayne if it's in both the names or not. He's the owner.
Well, have you gotten a bill in both names? Did Ms.
Yeah, she
Georges
has
sign
a
a
bill.
contract?
She has a copy of it. It was given to her.
All right, to be on the safe side, Ms. Georges, he said he'll pay it.
Yeah, I will. I'm paying all
who's the
this.
creditor? To whom is the storage fee due?
Yes, I'm taking all of it.
Mr. Georges,
Yes,
what's the
sir.
name of the creditor?
Well, Dwayne Storage.
Okay, Dwayne Storage. So Miss George write in the judgment that he, Ronald will also pay the storage to Dwayne Storage.
Right.
Okay, then it will address that.
Okay.
Whether they're in both names or in one name, Mr. George will pay all those debts.
Okay, yes.
Okay. All right, anything further, Miss Georges?
No, Your Honor, that covers it.
So
Ms. Georges, if you can't
Joshua
prepare the
and
judgment, if you can't prepare the judgment, contact an attorney. Attorney can help you prepare that. You're not gonna be divorced till the court signs a judgment reviewed and approved by both of you.
yes, so we've agreed on $3,000 personal loan, $3,000 for MasterCard, and half of the fifth wheel.
Yes.
Correct. In addition, you've agreed that Ronald's gonna pay the debt to Dwayne Storage, American Express, and Home Depot.
Yes, yes.
Okay.
So you gotta spell all that out.
Okay, yes.
Right. Mr. Georges, any other questions?
No, sir, Your Honor. Thank you.
Hey, come on, the two of you are adults. Work together.
That's why
Get
we're
this
getting
judgment entered.
Abuse.
All right, thank you, Mr. Walker. And again, to make a note, you got to put in the judgment too, Ms. George, you're going to pay the 175 filing fee on them for June 28th. If you need to borrow that money, get that paid.
Yes, Your Honor.
Very well, based upon the testimony, thank you, Mr. Walker, for your assistance. Based upon the testimony that's been presented this morning, as well as the complaint filed this matter, the court finds that jurisdiction has been established and that there's been a breakdown of the marriage relationship to the extent that the opposite matrimony has been destroyed. There's no reasonable chance of reconciliation. According upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce with bonds matrimony. All right, that will conclude this hearing. You can both zoom out. Ms. Georges, get to work on that judgment. If you need to come down to the courthouse, we can give you a copy of these forms. Okay.
Thank you.
Then either
Thank
mail it to
you,
Mr.
Your Honor.
Georges or have a mutual friend deliver it to him. Okay, right. You can
Thank
both
you,
zoom
Your
out.
Honor. Thank you.
Welcome.